Good morning. This is the appeal in Robinson, Jamaica, against the Secretary of State for the Home Department. Mr. Southey, Queen's Counsel, represents the appellant, and I'm going to turn to him immediately to open the appeal, please.
My lady, I appear for the appellant in this matter with my learned friend, Mr. Palmer. My learned friend, Mr. Blundell, Queen's Counsel, appears with his learned junior, Ms. Smythe, on behalf of the Secretary of State. My lady, as I'm sure the whole of the panel is aware, the issue in this case essentially is the circumstances in which a child can be denied their EU treaty rights on the basis essentially of their parents offending. And in that context, I'm going to start by addressing the facts very briefly, then turn to the law, and then turn to the materiality of the law on the facts. Before doing that, I should just mention one matter which might be thought of as sort of the elephant in the room, which is the United Kingdom's exit from the European Union. I think the agreed position is, sorry,
Sorry, Mr. Southey, I've got a dreadful time delay with almost a recorded version of our hearing going on in the background. So I'm just trying to contact the engineer. Can we just pause for a moment, please?
Yeah.
I'm sorry about that technical hitch. We can start again now. And I particularly apologise to Mr. Southey for interrupting him in the beginning of his submissions. It was my fault entirely.
No problem at all. What I was saying was that I thought before sort of getting into the substance of my submissions, I should just mention in passing what might be thought of as the elephant in the room, which is the United Kingdom's exit from the European Union. And I think the agreed position, reading the two cases, is that at today's date, EU law continues to apply, and the exit essentially can be ignored. Whether that will be the case by the time judgment is to be delivered, assuming judgment doesn't take place this year, is more uncertain, but there's not much I think we can do about that, and so it may be that further submissions are required if judgment isn't delivered this year. But I'm not, as I say, I think both parties are agreed there's little we can do about that at this stage. Turning then to the first stage of our argument, the facts. I'm going to deal with them very briefly, but I am conscious of the fact that relatively recently this court criticised essentially the failure to engage with facts when proportionality was an issue. And I'm thinking of Nuazali. I'm not going to take the court to it, but it's paragraph 18 of Nuazali, which is at page 279 of the authorities. And we certainly would submit that when looking at proportionality, the facts are obviously always relevant and need to be borne in mind, because proportionality is ultimately a fact-specific exercise. And with that in mind, the key facts we would submit are these. The appellant's conviction dates back to the 5th of October 2006, when she was sentenced to a 2.5-year sentence of imprisonment. The reference to that is paragraph 13 of the Court of Appeal judgment. It's not in the papers, but it's consistent with the sentence. As I understand it, she was then bailed on the 18th of March 2008, which means that by the time the Court of Appeal considered this case, she had been at liberty for almost 10 years.
Oh.
And that means in our submission, there was very little basis, essentially, no real basis for concluding that she was a risk. And indeed, although my learned friend says correctly, essentially, that in the upper tribunal there was no consideration of the risk she posed, if one looks at the first tier tribunal's determination, which relevant pages I think, page 128 of the core bundle. First tier tribunal's determination, paragraph 39. The Secretary of State's case essentially seemed to be put on the basis that past offending was the justification for deportation rather than current risk. The offending led to a deportation order. The deportation order was made on the 20th of November 2007. And critically for these purposes, there was then a refusal to revoke that on the 29th of August 2012. And that is the decision that's formally in issue in this case. The reference to those two dates is paragraph 14 of the Court of Appeal judgment. The other factor that is clear in this case, or the other fact that is clear in this case and critical, is that on the 29th of December 2008, the claimant gave, the appellant rather, gave birth to a child. That child has lived with the appellant throughout his life. One sees that paragraph 10 of the upper tribunal judgment. Its father, though, or his father, left home on the 20th of February 2012, which comes from the same paragraph. And in light of that, it wasn't surprising that the upper tribunal was clear, and it's paragraph 11 of the upper tribunal's judgment, that effective care of the child was in the hands of the appellant, such that if the appellant were to be removed, the child would effectively be removed. And there was, the tribunal was clear that neither the father nor wider family members could be expected or would be expected to care for the child. And that child is a UK national, there's no dispute about that. That's paragraph 13 of the upper tribunal. And it's those findings that mean that the child is what is sometimes called in the shorthand a Zambrano child. And I say that because we'll see in a moment, Zambrano establishes the right of that child to reside in the United Kingdom. So that's the background, and that's essentially the facts as they were before the Court of Appeal. Turning then to the law, the starting point in our submission, because in our submission the rights in issue are derived from this source of law, is the Treaty on the Functioning of the European Union. And if we go to the core authorities, tab 3, page 265 of the electronic bundle, one sees there articles 20 and 21 of the Treaty on Functioning of the European Union. And Article 20, paragraph 1, is the article of the treaty that establishes citizenship. Article 2, or paragraph 2 rather, sets out rights that are derived from citizenship. They obviously include free movement, but they include residence as well. And one of the issues that we submit has essentially been decided by the Zambrano line of case law is that residence essentially is a separate right, because that must, in our submission, be the consequence or the basis rather of the Zambrano rights. But those rights aren't simply movement and residence. There are a number of other rights. They are rights that I'd have to accept are probably less significant in the context of a child, but they're important in this sense. They demonstrate in our submission the fact that citizenship of the EU is intended to be a status which goes beyond free movement. They're intended to, it's intended to be a fundamental status, to use the language of some of the judgments. should also say that although there are 4 subparagraphs essentially identifying rights, in our submission, and we'll come to this, as was identified by the Advocate General in the CS and Marin judgments, in our submission, these rights aren't the only rights that flow from citizenship. And for example, the right to equal treatment, which is identified by the Advocate General, is an important right. I'll come back to that. Article 21 then essentially identifies again, almost repeats essentially what is said in Article 20, subparagraph 2A, in that it identifies the right to both move and reside. And there are further rights, as I say. Article 22 also talks about the rights to stand in elections. Not a, again, obviously not a right that's particularly relevant to children, but again, we would submit it's a right that demonstrates how citizenship is meant to be more than just about free movement. And that's the, and what we would submit is that the articles that I've just taken the court to are the key rights, are the key starting point rather, because they demonstrate how citizenship is meant to be a central concept within the European Union legal order. And that is, in our submission, as I say, at the heart of Zambrano. And so my learned friend's submission, essentially in his written case, that Zambrano is at the edge of EU law, in our submission is wrong. Not sure in one sense how that helps, but to the extent it is relevant, we would submit it's wrong, because Zambrano, we would submit, is based on a key concept that is incorporated within the treaty system. The treaty provisions that I've just drawn attention to are probably not the only treaty provisions that one needs to bear in mind. The Charter on Fundamental Rights and Freedoms, which is given effectively treaty status, it also is relevant. That is at tab 2, paragraph, page, the relevant page probably to start with is electronic page 259. And I take you to that because that, again, at paragraph 45, identifies the right to free movement and reside. But again, in the same way that the Treaty on Functioning of the European Union identifies other rights, one sees above that other rights identified. Probably more importantly in some senses, because it's referred to in the case law and in our submission is entirely consistent with the approach that is adopted in the case law. If one goes to back 2 pages to electronic 257, one sees Article 7 of the Charter. And Article 7 essentially provides that there is a right to private and family life, obviously very similar to Article 8. And that is something that is referred to in the relevant case law. And then Article 24, again referred to in the relevant case law, which is the rights of the child. And this obviously goes beyond the express terms, at least, of the European Convention on Human Rights. The European Convention's case law makes reference to similar concepts, but it does go beyond the express terms of the European Convention and identifies 3 specific rights: the right to protection and care, the right to have best interests taken into account, and the right to maintain on a regular basis a direct and personal relationship with parents. And those last 2 provisions in our submission are particularly important The best interest provision we submit is important because the case law on best interest, and I'll take you to that briefly later on, makes it clear that when looking at best interests, there is a significant interest in a child being able to enjoy residence within their country of nationality. And certainly we would argue, although obviously the EU is not a nation, it is a territory which has certain standards, and there is an analogy that can be drawn because children clearly in our submission have a similar interest in being able to being able to be brought up within that territory. The other right that I highlight is paragraph 3, the right to maintain contact, because essentially, in one sense, the Zambrano principle is an attempt to ensure that children aren't forced to choose between losing contact with their carer and losing their right to reside within the EU. And the Zambrano principle is a way essentially of ensuring both those rights are safeguarded. And that is an indication we would submit of the importance of the Zambrano principle. The final provision of the Charter that I should draw attention to at this stage is Article 52.3 of the Charter, which deals with the relationship between the Charter and the European Convention on Human Rights, and makes it clear that the convention in our submission is what might be described as a floor, not a ceiling, so that the EU will respect, particularly in the Charter context, European Convention rights, but the EU can go further. And so one sees, in one sense, that in Article 24, which we've just been looking at, which is an express provision not reflected in the Charter. Sorry, in the Convention. I should say in passing, if one goes to Authorities Bundle 2, electronic page 576, just really for completeness as much as anything, one sees there Article 6 of the Treaty on European Union, and that's relevant for two reasons. Firstly, it makes it clear in Article 1 that the Charter has the same value as treaties. The point I was making a moment ago, but that's the source of it. And in paragraph 3, it again refers to the Convention, European Convention, and makes it clear that the Convention essentially is, well, it says expressly the Convention is general principles of EU law. So consistent with the point I made before, which is the EU can provide more than the Convention, but it can't provide less, essentially. And that means, essentially, we would submit in simple terms, we can rely on Convention decisions as being relevant to demonstrate minimum standards. It's a bit more difficult for Malone and Friend to rely on them as demonstrating maximum standards. Can I then turn to the Zambrano case law? And before going into the detail of that, it certainly, we would agree, I think, with Malone and Friend, that there are probably 4 key authorities in this context. Zambrano itself, and then 3 subsequent decisions, S, Rendon Marin, and KA, that address the specific issue of when Zambrano rights can be denied. Now, in that context, we would say that S is the most important. And there's a simple reason for that. The other two of those cases that look at the circumstances in which Zambrano rights can be denied, Rendon Marin and KA, were both cases rather concerned with a domestic legal system that had no flexibility within it to grant Zambrano rights, essentially. And so the issue in those circumstances, the primary issue, and the issue that the court answered in its questions, answered in its answer rather to the questions, was whether such an automatic rule was compatible with EU law. S is slightly different because the UK legal system, which was an issue in that case, did potentially allow for Zambrano rights to be taken into account. And so we would submit the Court of Justice went into slightly greater detail about the circumstances in which Zambrano rights can be constrained. So I'll probably spend greatest time on S. What I will also, though, try and do is that I am very conscious of the fact that, as is common in both jurisprudence of the CJU and the European Court of Human Rights, there are common passages that clearly have been cut and paste from earlier judgments. So I'm going to try and avoid just going through the same passages in different judgments, because I recognise that's probably not going to be of much assistance. Turning then firstly to Zambrano. Zambrano is, I think the facts of Zambrano are probably well known. It's at tab 8 of Core Authorities volume at page 443. The facts essentially are set out in the head note. And the facts are very straightforward. The background is that the claim was essentially brought by two Colombian nationals who had Belgian children. And they sought essentially to enforce rights, and in particular rights to a work permit, based on their children's status as Belgian nationals. And I'm going to start by going to the opinion of Advocate General Sharpston, not in some senses because of what she decides, because actually her conclusions are significantly different to those of the European Court, and I'll make some reference to that in a moment, but because of what she identifies as being the questions in issue, because in some sense I think that helps. If one goes to electronic page 448, paragraph 3, just below letter F in the report, Advocate General Sharpston identifies essentially the question as being, is European citizenship merely the non-economic version of the same generic kind of free movement rights as have long existed for the economically active and for persons of independent means? Or does it mean something more radical, true citizenship carrying with it a uniform set of rights and obligations in a union under the rule of law, in which respect for fundamental rights must necessarily play an integral part, rather. Now, I draw attention to that because although the judgment, none of the judgments expressly deal with that question in terms, in our submission, when one looks at those judgments, what they're doing essentially is analysing citizenship as being a fundamental status, applying it in circumstances where the court is very conscious free movement doesn't apply, and as a result, essentially adopting an approach which is consistent with citizenship being true citizenship. Now, Advocate General Sharpston went on to identify a second linked issue, essentially, paragraph 81 of her opinion, which is page 465 of the electronic bundle, which is, again, in some senses, it's a similar point. The question she identified there, paragraph 81, was whether the right to move and reside, and we've already seen that's in both Article 20 and Article 21 of the Treaty of Functioning, whether that right essentially is a right that can only be invoked when there's prior movement, or whether essentially move and reside are disjunctive so that one can rely on them when there's been no prior movement. Now, again, that is not expressly engaged with, but our submission is that when one looks at that, the conclusions of the court must be essentially that the rights are disjunctive, because that's why essentially Zambrano rights arise in the context of someone who has never exercised free movement rights and where there was no particular reason to believe they intended to exercise free movement rights. Should say in relation to that, because it's of some relevance possibly, because it identifies a legal basis essentially for concluding that the rights are disjunctive. At para 84 to 86, Advocate General Sharpston essentially identifies reasons why the rights should be disjunctive, based both on what she described as a paradox if they weren't, and case law that supported that conclusion. But that's the context then of the court's judgment. If one goes to electronic page 496, paragraph 40 to 44 are probably the key passages in the court's judgment. The court starts in paragraph 40 by noting that citizenship is conferred on every person holding the nationality of a member state. No, not suggesting it's limited simply to people who've exercised free movement rights. Then the second paragraph, sentence rather, in paragraph 40, it notes that the children in question were Belgian, and so they were EU citizens. Paragraph 41, the court describes citizenship as a fundamental status. That language in our submission, although not expressly answering the question asked by Advocate General Sharpston, is consistent with the court essentially concluding that citizenship was not simply an aspect of free movement. It was intended to be something more important and something central to the European Union legal system. Paragraph 42 then, following on from that, essentially concludes that Article 20 precludes measures which have the effect of depriving EU citizens of the genuine enjoyment of the substance of their rights. Note there the plural rights, no suggestion that the only right in issue is free movement. linked to that, paragraph 43 indicates that a refusal to grant of right of residence has such an effect. We would submit the obvious reason why it would have such an effect is it deprives people of their right of residence. Certainly, there's no suggestion there that one needed to be exercising free movement rights before one could rely on that principle, and obviously free movement wasn't being relied upon in that case, wasn't being exercised in that case. And that led to the conclusion, essentially, that the rights, as one sees in paragraph 44, claimed were ones that were properly claimed, essentially because the children would be unable to exercise their rights if they were required to leave. So one sees there that the Zambrano rights essentially are the rights of the child, something that is emphasized. They are the rights of the child because the child has a fundamental status under EU law. And the problem that the court identified essentially with requiring the parents to leave is that requiring the parents to leave prevented the children exercising their rights as EU citizens. Now, the court doesn't expressly say there what rights it's concerned about, but the obvious right is the right of residence, because that is the right children were exercising. To put that in context, there is no reference there to it simply being about free movement. And indeed, to go back, if one looks at paragraph 37 of the judgment, the government who made submissions, because it was more than just the Belgian government who made submissions, the government who made submissions essentially argued it was relevant that there was no exercise of free movement rights. And the answer given by Mr. Ruiz Zambrano essentially was reliance on citizenship didn't depend on exercise of free movement because there was a right of residence. And although that submission isn't expressly accepted in those terms, the outcome of the judgment certainly implies that it is accepted. One other feature of the judgment I should probably draw attention to, given what's actually at the heart of this case, the right of the third country national is ultimately set out in the answer the court, the CJU, gave to the domestic court, and one sees that page 497. And that essentially is expressed in what might be described as absolute terms. There's no qualification of that right. Now, that is significant. I mentioned before how the Advocate General's approach was slightly different. And the biggest difference, essentially, between the approach of the Advocate General and the court is if one goes back to 488, or 178 of the Advocate General's opinion, the Advocate General expressly stated in her suggested answer that it should be possible essentially to deny Zambrano rights, providing that the decision complied with the principle of proportionality. And so the Advocate General, on the face of it, alerted the court to the possibility they may want to find that there was a possibility of qualifying Zambrano rights, but the European Court didn't expressly adopt that in the Zambrano judgment. Now, I'm not suggesting that implies, because it clearly would be impossible for me to suggest that, given subsequent case law, that Zambrano rights can't be qualified. But what I am suggesting is that the court was certainly implicitly identifying the fact that Zambrano rights are difficult to qualify, because it was not at this stage willing to identify possible qualifications of those rights. Zambrano was then followed by the two joint cases of Rendon, Marin and S. I say joint because they were heard together, and the Advocate General in that case, Advocate General Suspner, produced a joint opinion. And his opinion is set out in the report to the Rendon Marin judgment. And he, in the course of that judgment, sought to identify again the fundamental nature of citizenship within the EU. If one goes to it, the report is at tab 7 of the core volume of authorities, and the relevant passage, the first passage I'm going to take to, is at electronic page 407. Paragraph 108. And 109 is where the court essentially, having set out, one sees at the top of the page in paragraph 107, the fact that citizenship was said to be fundamental. 108 and 109 is where the Advocate General seeks to set out the rights essentially that flow from citizenship. And in paragraph 108, identifies firstly a right to move throughout the Union and reside anywhere. I emphasize that because clearly anywhere includes one state of nationality. And then paragraph 109 sort of flows from paragraph 108. Identifying within it right to equal treatment of workers, the right to move freely again, and equal treatment more broadly. But the reason I draw attention to that is that when one reads that as a whole, particularly with paragraphs follow, and I'm about to take you to, one sees there the Advocate General again identifying sort of fundamental nature of this status, which includes free movement, but isn't limited to free movement. That's the context, essentially, of paragraph 116 of the Advocate General's opinion, and 117. Paragraph 116 is where the Advocate General in particular addresses Ruiz Zambrano. And indicates in particular that Ruiz Zambrano, in his opinion, is based on what he describes as fundamental status. Then based on that, paragraph 117, he seeks to summarize what he regards as being the fundamental nature of citizenship. And one sees that one goes to the last 8 lines in paragraph 117, which begins with the sentence, that status binds them together rather as peoples of a Europe that. And I'll ask the court just to read that. And what, in my submission, is significant about that is that, in my submission, that indicates that Advocate General Spuzner believed essentially that the CJEU, or was the opinion that the CJEU had answered the first question identified by Advocate General Sharpston. One remembers back to that question about whether or not citizenship was something more than free movement, in terms that indicated it was something more than free movement. It was a fundamental status. We submit that that's correct on a reading of a fair reading of the Ruiz-Zambrano judgment, and it's correct on a fair reading of the case law that follows. One other aspect of this opinion that's worth noting, because it does seem to be, in our submission, the origin essentially of a feature of this jurisprudence which we haven't seen so far, but we'll see in a moment, is that paragraphs 151 and 152 essentially are where the Advocate General indicates that he certainly can't see any reason why the expulsion of Ruiz-Zambrano parents should attract lesser protection than the protection that applies when people enjoying free movement rights are expelled. And in my submission, one sees that then reflected in the fact that the language the court uses when it indicates the circumstances in which a Zambrano child can be expelled, that language reflects essentially the free movement directive, as we'll see. Can I then, rather than carrying on with Rendon Marin, for the reasons I already indicated, which is that S is the case that is specifically about essentially the exercise of discretion or exercise of power to expel, take the court to the judgment in S. And the S is at tab 9 of the core bundle. And the relevant passage is at page 506 of the judgment onwards. And it starts at paragraph 24. And in our submission, what the court does at paragraph 24 is essentially repeat the Zambrano principles, but it does so using slightly different language. And so I think I do need to go through that. Paragraph 24 is where the court, using language which I think very closely reflects, if not entirely reflects, the language of Ruiz-Zambrano, starts again by looking at citizenship being the fundamental status and indicates how it's possible to rely on one's rights. Perhaps one development is that it does refer to it being possible to rely on those rights against the member state of which one is a national. Come back to that. It then talks about, in paragraph 25, how citizenship confers a right to move and reside. It doesn't expressly, I accept, deal with the issue identified by Advocate General Sharpston, which is, are those rights disjunctive, to use her language? But we would certainly submit that the implication of paragraph 24 is that they are disjunctive, because if one is going to rely on the right to reside against the member state of which you are a national, that would suggest the right of residence can be a separate right. It can arise essentially whether or not you've exercised free movement rights. Paragraph 26, again, reflects Ruiz-Zambrano, in that it talks about how measures rather are prohibited which have the effect of depriving someone of the genuine enjoyment of your rights. Then paragraph 27 is, I think, is a paragraph that wasn't in Ruiz-Zambrano, which talks about how there are no autonomous rights on the third country national. And that's an express statement of a principle that I already accepted, I think, in relation to Ruiz-Zambrano, which is that the rights in question essentially are the rights of the child. They're not the rights of the third country national. And that's also reflected in the first sentence of paragraph 28, which talks about how the rights of the third country national are derived rights. Now, paragraph 28 is followed by a second sentence, which my learned friend places significant weight on, which is that the purpose and justification of such such rights is essentially the fact that they will interfere with freedom of movement. Now, in my submission, that cannot mean that is the only justification, because it would be, in my submission, inconsistent with the broader statements about the importance of citizenship that are the foundation of Zambrano and S, and it would be inconsistent with the fact that both of those cases, and indeed the cases I'm going to take you to in a moment, are cases where there was no exercise of free movement. What the court cites there, cites two authorities, one of which I'm going to take the court to in a moment. It cites the judgment, particularly paragraphs 67 and 68 of IDA. I'll take the court to IDA in a moment, because what IDA demonstrates in my submission is that although there are derived rights which are associated with free movement, the Zambrano principle is essentially separate from those categories of cases, because it's a situation where there's been no exercise of free movement. And that indicates in my submission that while there may well be derived rights, and indeed in many cases there are derived rights that are associated with free movement, they're not necessarily associated with free movement. And consistent with that, paragraph 29 goes on to look at the sort of circumstances of the case in issue, and expressly says essentially that there are circumstances where there can be a derived right, despite the fact that no use has been made of freedom of movement. And it explains that on the basis that in those cases, effectiveness of citizenship would be undermined. So it is clearly concerned with the fact that citizenship rights can be undermined even by the expulsion, essentially, of a parent, a Zambrano parent, even if there's been no exercise of free movement. And that then led it to conclude, the European Court to conclude in paragraph 30, that even though essentially residence in circumstances where there's been no free movement generally falls within the competence of member states, essentially where there was a sufficient connection with the right of free movement and residence, EU law interferes. Now, that must mean essentially either free movement or residence, because it's talking about the situation where there has been no exercise of the right to free movement, but a child is residing within the EU. Consistent with that, in paragraph 31, it described how the child in question had a right to move and reside, and any limitation fell within the scope. And so deportation essentially of the child's parent, the mother in that case, was essentially a requirement for the child to leave the European Union. And that's why the Zambrano principle was essentially engaged. But again, in our submission, that must be focused on the right of residence, because as was recognized essentially in that case, that child had not exercised free movement rights. As I say, overall, although there are greater references to free movement in that judgment than Zambrano, as I already indicated, Zambrano, essentially, the only references to free movement were references that recorded the fact free movement wasn't an issue in that case. Although there are greater references to free movement in the S case, ultimately, what's an issue in S, in the same way as Zambrano, is the fact that the departure of the mother, or the enforced departure of the mother, is going to require the child to depart, and that is going to be an interference with the child's fundamental rights. And one then needs to ask what those fundamental rights are, and those fundamental rights in our submission must be the rights of residence. Now, S represented a development of the case law for a second reason, which is that it, as well as Rendon Marina, the first case is essentially where the court recognizes that the Zambrano rights of a child and its parent can be interfered with if there's sufficient justification. And this is really addressed at paragraph 36 onwards of the court's judgment. Paragraph 36 recognizes essentially that public policy and public security grounds may justify the expulsion of a parent. But if that's going to happen, it requires account to be taken. The European Court requires account to be taken of the private law rights and the best interests of the child. One sees that in the second and third sentences within paragraph 36. One sees that justification has to be interpreted strictly. And one sees some general statements about at para 38 and 39 about how, in particular, public policy and public security can be established, or public policy grounds can be established, and public security grounds can be established. And in that context, one sees reference to, for the first time, genuine, present, and sufficiently serious threat, a concept that one sees in the Citizenship Directive, essentially. And that language of genuine, present, and sufficiently serious threat is repeated at paragraph 40. And also at paragraph 46. Based on that, one sees paragraph 47 a statement that there is a need to assess the extent to which the criminal conduct is a danger to society, and any circumstances where the conduct, any consequences rather of that conduct. That is a paragraph which, as far as I'm aware, and I'm always a little conscious of the dangers of saying something isn't present, because it's always a little more dangerous, a little more difficult to know what isn't present. But that's a paragraph essentially that isn't repeated in Rendon Marina and isn't repeated in KA, but is in my submission there essentially because the court here is giving greater detail essentially about the sort of factors, the approach that's required essentially when the approach that's required essentially when a child and its parent are going to be denied their Zambrano rights. Paragraph 49 is where the court talked about the importance of factors to do with the interests of the child. Paragraph 50 is then where the court ultimately sums up its conclusions in terms that essentially are reflected in the answer to the question. And essentially in two long sentences in paragraph 50, the first sentence essentially repeats essentially the Zambrano principle. And the second sentence then qualifies that, noting that in exceptional circumstances, the measure can be, the rights rather can be constrained where there is personal conduct which constitutes a genuine, present and sufficiently serious threat. A couple of points about that. Firstly, again, one sees that language of genuine, present and sufficiently serious threat, language which reflects in our submission the Citizens Directive. Secondly, we do submit that language of exceptional circumstances is deliberate language, and it is there essentially to reflect the threshold. If all it was intended to do was indicate that there could be an exception to the general rule set out in paragraph 50, the first sentence of paragraph 50, that sentence wouldn't have been necessary, because essentially all that follows is setting out an exception to the general rule. In our submission, what the court is seeking to do is recognise that where, given that a risk needs to be sufficiently serious, in this context, it is, those sufficiently serious is a high threshold, essentially. Thank you. My lady, I think you have a question.
Yes, I was going to say that we normally have a break at around this time because it's quite difficult looking at screens for a protracted period of time. But before I do that, can I give you something just to think about over the
Yes, certainly.
5-minute break? Just wondering whether the reference to exceptional in paragraph 50 is perhaps picking up the mention of there being an exception in paragraph 36.
Thank you.
So should we have 5 minutes and come back at 6 minutes past 12, please?
Thank you.
Thank you. Thank you very much indeed. We can now start again. Thank you, Mr. Southey.
Thank you, my lady. Can I then obviously answer your question as best I can first? And your question was essentially, is the reference to exceptional circumstances a reference back to the reference to there being an exception permitted by or an exception being permitted, and that reference is found in paragraph 36. I would say it's not, and I'd give 3 reasons for that. Firstly, the language of exceptional circumstances is not the same language essentially as the language of there being an exception, because in our submission it does imply something about the threshold. In fact, if all that was required, all that the court was saying was that there was an exception, as I think I said before, you wouldn't have needed any reference to exceptional circumstances in the second sentence in paragraph 50, because all you'd need to say essentially is first sentence, which is what's already there is a Zambrano right, but second sentence, expulsion measures are possible. And what, in my submission, the words exceptional circumstances are intended to do and make it clear essentially that the exception that's permitted by the second sentence is one that is only available in exceptional circumstances. Consistent with that in our submission is the second point I'm going to go to in a moment, which is the fact that if one goes to rendon marin, the language used, it reflects the fact that the question in that case was very different. It was about whether or not an automatic rule was permissible, an automatic rule under domestic law. And so there's no reference to exceptional circumstances, no reference to the circumstances in which you can deny someone Zambrano rights at all. And that, in my submission, suggests that the language being used here is the Court of Justice's attempt, essentially, to indicate what the threshold is, what criteria need to be met before Zambrano rights can be denied. But thirdly, and possibly most importantly, in my submission, if one looks at the context, there's good reason to believe that the threshold is a high one, and I'll come on to that in a moment. But I refer in particular to the Citizens Directive and also the case law generally about the best interest of the child. And for both those reasons, in my submission, there's good reason to believe that the threshold is a high one. So it's not surprising that the court should have been seeking to indicate it's a high threshold before you can deprive someone of Zambrano rights. Can I then turn, I don't think there's anything more I can say about S. Can I turn very briefly? Sorry.
Lord Lloyd-Jones.
Mr. Southey, before we leave this passage, do the other language texts cast any light on this?
I've been through quite a lot of them, and I don't think they do. As far as I can see, I mean, my language skills are pretty poor, but as far as I can see, the language used is essentially very similar, and in all the language versions I was able to look at.
I see. We don't have any of those other language versions in the papers, do we?
We don't. Obviously, we can provide any that the courts would want.
Right,
I think the conclusion ultimately reached was we didn't think they would be of huge assistance, but we can certainly provide them.
Yes, Mr. Southey, could I ask a question just before we move on from this passage?
Yeah.
In paragraph 37, the court has emphasised the strictness of any derogation from right of residence.
Yes.
As I understand it, you're seeking to suggest that the reference to there being exceptional circumstances adds an additional layer of exceptionality. But isn't that already catered for in the way in which the court has structured its discussion here, already emphasising that a right of derogation is to be interpreted in a restrictive fashion? Which,
well,
when added with the point that my lady put to you, it might be said to, that when the court refers to exceptional circumstances, in particular in paragraph 50, all it's doing is summarising what it has said already in its discussion leading up to that conclusory paragraph.
Well, if what my lord is saying to me, and this would be one way of reading it, is that what paragraph 37 is indicating essentially is that there is a high threshold here for reliance on public policy and public security grounds, then I suppose one way of reading this would be to say that exceptional circumstances is essentially shorthand for that high threshold. But it's an indication of how narrowly the exceptions need to be read, essentially.
But is this right then, that if one reads it in that way, exceptionality as such is not an additional criterion?
Well, our case, I think, as we put it, is that what exceptional circumstances is intended to indicate is that this is a high threshold. So if one reads paragraph 37 essentially as importing a high threshold, that would be consistent with that. But it in the critical, there's always a danger, I think, in perhaps sort of having a reinterpretation of something which anyway is intended to provide relatively simple guidance. But what our point is about exceptional circumstances is that is intended to indicate a high threshold, and we would submit that paragraph 37 is consistent with that.
Yes, thank you.
Can I then turn very briefly to Rendon Marin? Rendon Marin is at tab 7 of the Courts Bundle, judgment delivered at the same time. The difference being, essentially, as one sees several places in the report, one position perhaps, or one place, being the Advocate General's opinion at paragraph 32, which is at page 393 of the electronic bundle. The Spanish law in question essentially gave the court gave the decision maker no discretion. Once there'd been a criminal conviction, there was no possibility of varying the prohibition on residence permits to take account of Ruiz Zambrano. And that was reflected in the court's answers. And so, and both the, well, not just the court's answers, the Advocate General's answers as well. One goes to the Advocate General's answers at page 419, paragraph 176 and 177. 176 is where the court sets out its answers in relation to, or not the court, the Advocate General rather, sets out his proposed answers in relation to Rendon Marin. Says nothing essentially about the circumstances in which the Zambrano principle can be denied. What it says is essentially that you can't automatically deny someone their rights on the basis of a criminal conviction. And that's then reflected in the answer given by the court at paragraph 89, page 442. So in our submission, there's very little in many respects to be gained from Rendon Marin in addition to what's in S, because it is dealing with, in one sense, a prior issue, which is whether or not you can have an automatic rule. And so that explains why there's less consideration in the judgment of the circumstances in which it is legitimate to deny Zambrano rights. These two judgments were followed by KA. KA was again about automatic rules. One sees that at page 359. Paragraph 18 and 19. Of the Advocate General's opinion. And so again, there's perhaps less consideration essentially of the circumstances in which one can deprive someone of their Zambrano rights. What I would say, it may be of some significance, given, as I say, the focus my learned friend puts on this being linked to free movement, is that if one goes to the summary of the Zambrano principles in the court's judgment at page 367 to 368, I'm not going to go through it in detail. Essentially, the only reference to free movement is is in paragraph 48, which talks about the right of the citizen to move and reside. And as you've already heard me submit, certainly we submit, residence and free movement are separate.
Sorry, Mr. Southey, could I take you, before we leave the Advocate General,
yes,
take you to page 348, where Advocate General Sharpston posed the question as to whether Directive 200, the Citizens Directive, should just be lifted and transposed into this derivative right, and she thought not. And certain principles could be, but others couldn't be. And wasn't that exactly the outcome in the Marion case, insofar as the Advocate General in that case wanted to transpose Article 38(3), and the court declined to do so?
Well, in my submission, the court, what the court in the Rendon Marin case, the Advocate General argued that there was an analogy, and I'm not sure, and I'm always very conscious of the point I made before about saying something isn't present, but I'm not sure there was an express reference there to Article 28.3. It's fair, I think, in the Rendon Marin case, that there was a reference to the European Commission referring to Article 28, which I think is at page 416, page 157.
Article 38.3 was specifically referred to by the Advocate General in Marin, and the Court of Justice didn't apply that higher standard. Is word for word.
Well, I'm not sure I've got the reference in Render Marin to the Article 28.3. Certainly, the court didn't expressly. I mean, the court didn't expressly engage with that issue, and ultimately, the answer given, by the court was, although not identical to the answer proposed by the Advocate General, was very similar, essentially.
There is no mention of imperative grounds at all in the Court of Justice, the European Union's decisions.
There's no reference to that language, which is it's fair to say is found in the language of the answer. But the reason we submit that's the case is because the court was making it clear in any event through exceptional circumstances that there was a high threshold.
Yeah, thank you.
I mean, what the court doesn't do essentially is, what the court also does in our submission, which is consistent with our submissions, is it uses the language of the Citizens Directive, different provisions, obviously the Article 27 provisions from memory of the Citizens Directive, in its judgment. By implication, as a result, accepts there is an analogy that can be drawn. It doesn't expressly explain why that language was dropped, but it does use the language of exceptional circumstances.
I think, Mr. Southey, the passage my lord may be referring to is paragraph 168.
Yes.
At page 418, electronic bundle.
Sorry, yes, I couldn't find that's sorry, that's right. I was thinking also of the reference, as I say, that there is reference in the answer to the question, because it's fair to say, I think, as we addressed in our written case, if one goes to the question at page 177, that language of fundamental interests of society and imperative grounds, more importantly, imperative grounds, is at the answer of the proposed, is at the end of the proposed answer. It's not, it's fair to say, in the answer adopted by the court, which one sees at page 442, and that's what I thought the reference was when I was looking at it just a moment ago, on my feet, so to speak. And as I say, we submit that if one, I mean, the court doesn't explain that reasoning, but if one proceeds on the basis that exceptional circumstances is a high threshold, then perhaps that language, well, we would submit that language becomes unnecessary, essentially.
Thank you.
I'm not quite sure how you put your case, whether you're saying that there is an additional requirement that has to be satisfied, i.e. exceptional circumstances, or exceptional circumstances simply indicates the rigor that's to be applied.
Well, I think we probably put it in either way, essentially, but we do, our primary point is exceptional circumstances has to mean something in this context, and exceptional circumstances is an indication of the fact that the court was of the opinion that there was a high threshold to be crossed, and that a helpful shorthand essentially for that high threshold was exceptional circumstances. So I'm not, in one sense, I'm not sure it almost matters whether it's an additional requirement or not. It is ultimately an indication of how high the threshold is.
Sorry, but my difficulty, Mr. Southey, is that if you go to page 375 of KA, you get paragraph 94. Sorry, paragraph 91. You'll see that the words genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. That's a straight lift from paragraph 27.1 of the Citizens Directive.
Yes.
And if you turn over the page to 94, the nature and gravity of, some of the circumstances there are a straight lift from 28.1 of the Citizens Directive. But there are additions to it. For instance, the Citizens Directive does not refer to the legality of the residence. It refers to the length, not the legality. And obviously there has to be an addition because paragraph 94 refers to the nature and gravity of the offence committed. So which isn't in paragraph 28.1. So the Court of Justice again had the opportunity to adopt all of the language of the Citizens Directive, but they declined to do so, and specifically declining to adopt 28.3 and imperative grounds.
But, well, what I would say in response to that is that whether or not I am right or not to say effectively that language should be relied upon. The reality is that in any event, Article 28.3 demonstrates the importance consistent with the Charter of Fundamental Rights and Freedoms, Article 24, attached to the best interests of the child in this context. And in particular, it by implication indicates that consistent with Article 24, that the legal order of the European Union recognises the importance of children being able to remain in the country that they've spent much of their life in. And that is whether or not Article 28.3 can be directly imported or not. Those concepts in our submission explain why a high threshold has been adopted in this context.
Thank you.
My lord, my lady, rather, and my lords, can I then just, I'm conscious of time, so I need to probably sort of slightly speed up. And so I will give you some references rather than KA in particular, but the case law generally that I've just taken the court to was obviously reviewed by Lady Arden in this court in Patel relatively recently. Patel is in the core volume, tab 5, page 309. All I would say is that she, again, essentially identifies that this case law is based on the fundamental importance of citizenship. The relevant page, electronic page, is 309, and I'm referring in particular to paragraphs 9, 16, and 22. She bases, as I say, this case law on citizenship rather than free movement. And consistent with that, I also made reference to IDA, which is at volume 3, tab 30. Again, I'm going to give you the references rather than take you to it. It's page 910 of the electronic volume. And the passages that were cited by the European Court in CS and Rendon Marin were paragraph 67 and 68. But that's then followed by effectively identification of 3 circumstances in paragraph 69 to 71, 3 circumstances where derived rights are enjoyed. the first two of those are free movement cases, but then it's expressly I recognise that the Ruiz-Zambrano line is concerned with a circumstance where there is no free movement, but what is in issue is effective citizenship. And that, in my submission, demonstrates that at the heart of this is, as I say, the fundamental right to citizenship, and obviously a key aspect of citizenship generally is that you can't be expelled from a country where you hold citizenship. And that's why, in our submission, the Zambrano rights apply. Now, I've made reference to the Citizenship Directive. The Citizenship Directive is in the core volumes at tab 1, page 189. And obviously, the relevant passages are in particular Articles 27 and 28, and they start at electronic page 224. And there's already been reference, obviously, the language of the Court of Justice reflects certainly Article 27.2, indicating that what's in issue is certainly no less valuable, essentially, than free movement. It also takes account, essentially, of reflects to some extent, at least, the language of Article 28.1. What isn't referred to is, as my Lord Stevens put to me, is the language of Article 28.3. But Article 28.3 in our submission, in any event, is important because what it recognises is the importance of the rights of the child, and in particular the importance of the rights, the right to residence in our submission that children enjoy. And that's where, in my submission, one needs to take account, essentially, of the approach that Baroness Hale adopted in ZH. And can I take the court to Authorities Volume 2, tab 27, page 772.
Sorry, Mr. Senator, before we leave 28.3,
yes,
if you could help me in about this. If there is an expulsion of a minor,
yes,
is that final forever?
no.
As opposed to, sorry?
Sorry, my lord. I thought I was saying no, in part because no expulsion under the directive is meant to be forever.
But that's a distinction. Is there then a mechanism for the child to reapply, so that in discretion there can be the child can be let back into the territory again? Whereas with these children, Zambrano children, they don't have to rely upon any discretion or any application. They can just come back.
There is a discretion. Articles 32 and 33 essentially provide mechanisms by which people who've either been excluded or expelled, well, Article 32 really, because obviously if you've been expelled, you can come back unless there's an exclusion order, and it's Article 32 which deals with the length of exclusion orders.
Yeah.
But my lord, going back to your point, my lord is in one sense right, in the sense that I would accept, in the sense that because a measure taken against a Zambrano child, or rather a measure taken against the parent of a Zambrano child, to be more accurate, is not directed at the child themselves. The child can come back at any stage. The reality is that, of course, if their parent can't come back, it's difficult to see how they can exercise their rights, because the whole basis upon which they have rights as a Zambrano child is because it is only with their parent that they can effectively enjoy those rights. The only circumstances in which they're going to come back is if they are an adult, or if the parent is able to return. And in terms of if they're an adult, the problem with that, and this is where the dicta of Baroness Hale is potentially quite important, is that they will have lost that benefit of a childhood within the EU. Can I, as I say, take the court to ZH, and the relevant passage is page 772. Paragraphs 30 and 32 in particular. Where Baroness Hale identified how, in accordance with the United Nations Charter on the Rights of the Child, nationality, and in particular the ability to live in one's country of nationality, is a significant factor because of the importance, essentially, of being brought up in one's homeland. Para 30 is where Baroness Hale cites an Australian Federal Court judgment, WAN, and Para 32 is where she essentially refers to the importance of being able to be educated and grow up in one's own country. And my submission is this, essentially. Although EU citizenship is concerned with the right to remain within the territory of the EU, rather than being concerned with a particular country, that's certainly what it's primarily concerned with. The reality is that, and this reflects back to the Advocate General's opinion in my submission in Rendon Marin, the reality is that the EU does see itself as a distinct territory for good reason. It has certain minimum standards. That's why I drew attention to, for example, the right to equal treatment. And there are real benefits potentially to being within the EU during one's upbringing. And so the same sorts of factors essentially can be applied in this context. That's where, going back to Article 28.3 in my submission, whether or not it directly applies, it is still of some significance, because it recognizes, unsurprisingly, how the UN Charter on the Rights of the Child is essentially recognized within EU law. That's consistent, obviously, with Article 24 of the Charter. It recognizes how expelling a child from a state where they are located, where they may have ties, is a significant matter. I mean, in the context of Article 28.3, in fact, it's not concerned with expulsion from either the EU as a whole, and so losing all the rights that go with being in the EU, or expulsion from the state of the child's nationality, because by definition, the child must be exercising rights, free movement rights, because otherwise Article 28.3 doesn't apply. But despite that, despite, in fact, in some senses, one might think that the position of the child is weaker in those circumstances. It still recognizes that there needs to be a particularly powerful case before you expel a child. Now here, one's got the situation of a child being expelled from the EU as a whole, losing all the equivalent benefits within the EU. And that's why in my submission, it is possibly the case, and we would certainly argue this may well be the explanation of why the exceptional circumstances threshold is present, it may well be the case in our submission that an even higher threshold is required in this context. Now, I'm conscious of the time, and there's one other area I think I need to address very briefly, because it is of some importance in our submission, and that's the issue of materiality. And the reason I draw attention to that is because, in one sense, one indication of whether of the threshold that the Court of Appeal applied in practice is the outcome of the case, and the fact that the Court of Appeal remitted this case back for rehearing. And it remitted it clearly on the basis that it concluded that there was a need for up-to-date information about the child. That, in our submission, is not consistent with there being the sort of high threshold we're advocating or we're arguing for. And the reason for that, very simply, is that the sort of interest of the child only come into play if one already has a sufficiently high risk. And in the circumstances of this case, in our submission, the passage of time must mean that there is no sufficient evidence of risk. And in that context, we draw attention to one key concept we submit that is recognized both by the European Convention on Human Rights and the case law regarding that, and the case law of the CJEU, which is the importance of rehabilitation, essentially. And when a parent has served a significant prison sentence, then has demonstrated, essentially, by being at liberty for a significant period of time, that they have been able to avoid further offending. The implication has to be that they're rehabilitated, which is consistent, we would submit, with what I've already indicated, which was that the argument essentially relied upon by the Secretary of State at first instance was essentially that this is a child, this is a parent rather whose offending per se essentially justified the action. There wasn't any separate identification of continuing risk. And so ultimately we submit that the approach of the European Court, not the European Court, the Court of Appeal on the facts is inconsistent with this being a high threshold. And so we do submit that the arguments we've put about this being a high threshold are material on the facts. I think by editing down the second half of my submissions, hopefully not unhelpfully, I've finished 2 minutes ahead of time.
I wonder whether I can put something to you in the
Yes.
last 2 minutes then. What should the Court of Appeal have said? Because actually this is quite a short direction that it would give, if we look at it in those sorts of terms, to any upper tribunal or tribunal hearing the matter. What is the test?
The test is, well, the test we say is that there have to be, what we say the Court of Appeal should have said is that the use of the word exceptional circumstances demonstrates that there is a high threshold here that needs to be crossed. And in circumstances where at the time of the Court of Appeal's judgment, there had been no offending for almost 10 years since the appellant was released, it would be impossible for that threshold to be crossed.
That's going into a ground that you haven't got permission to argue. So I'm really looking at the test on the assumption that it has to go back, that you say should be applied.
Well, it's a high threshold. I mean, the reason I've tried to avoid sort of trying to reopen an argument, but equally, if the Court of Appeal should have gone beyond and said it was a high threshold, then we submit that is material on the facts, and so to that extent, we are able to argue about what should have happened, essentially. Thank you. I think now that's probably perfectly timed.
Yes, thank you very much indeed. I think that what we're going to do is to take an early lunch adjournment, if that's not going to cause difficulties with other people's arrangements.
No.
And then come back at approximately 1:45. We'll aim for 1:45. Would that be acceptable?
Yes.
Yes, of course, my lady.
Thank you. Certainly, my lady.
Okay. So we'll leave this now. Thank you very much.